Welcome to our presentation on how to prepare for and participate in mediation or facilitation. This presentation will review the Special Education Mediation Services intake process, how meeting logistics are handled, details about and how to prepare for a facilitation meeting or for mediation. Let's get started. This slide is a summary of how to request free services from SEMS. It's a good idea to save this as a reference for the future. You can reach us by calling 1-833-543-7178 or by visiting our website at mikids1st.org or mykidsfirst.org, where you will complete the request services form. Then you will participate in the intake process, which we will discuss next. We will contact the parties, arrange schedules, and process paperwork. And then the parties will meet. Our process begins with an intake call. Our specialists gather information from both the district and family, which will include the student's name, birth date, grade level, contact information for yourself and any other people you would like to attend the session. A release of student information form is sent to the parents, usually via DocuSign. It allows the district to share information about your student. It also serves as a record request. After the form is returned with a signature, SEMS can talk to the district about the case and get documents you haven't already provided. When signed, the district can share documents and talk to our staff and the mediator or facilitator. Then a case summary is prepared for the mediator or facilitator. The district is also going to be asked to share their information, their perspective, and participant information. The intake specialists are not permitted to offer advice, but they may provide links to information related to your concerns. When intake is complete and both parties have agreed to participate, the case will be sent to one of our 16 service partners. The case manager will take care of scheduling and assigning the mediator or facilitator. They'll also send the statement of understanding via that software I referred to earlier called DocuSign, which explains the process and the function of the mediator and facilitator. It includes confidentiality for each type of service as well. This goes out in advance to give the participants a chance to read it before the meeting. Often we're asked where the meeting will take place, and Special Education Mediation Services simply provides services where the family and the school agree to meet. This could be a local location within the district or somewhere virtually. Sometimes, if needed, the location is local and neutral. For example, our meetings are not always held at a school building. The average meeting length of a facilitated meeting is 97 minutes, and the average length of a mediation is about 104 minutes. It is not uncommon for SEMS to receive an intake inquiry on a Friday for a Monday meeting. So it's important for people to remember and understand what goes into how quickly we can arrange for services. As we've just reviewed, if it is a school-initiated inquiry, SEMS intake team asks for parent contact information. If it's a parent-initiated inquiry, SEMS will send a release of information form to the parent. The release must be signed and returned before we can contact the school. If both the parent and school agree to use services, SEMS intake staff will connect the parties to our regional center service partner by email. Then we or our center service partner will request the student records indicated on the release form. The center is going to coordinate your schedules, find a time that's mutually available unless the meeting has already been set. And then SEMS will assign a mediator or facilitator who is willing to serve that county on what is referred to as a random, rotational, or otherwise impartial basis from our statewide roster. And a statement of understanding for mediation or facilitation will be sent to all participants by DocuSign. We work really hard to meet the timelines and requests of families and schools, but it's really important to keep these steps in mind when those services are being requested to be expedited. So again, our response time, we have calls, emails, and website requests that are returned within 2 business days. Scheduling facilitations depends on the school and if a meeting date has already been selected. And for mediations, we average 19 days from the start of intake to case disposition or the resolution of the case. We make every effort to meet all service requests. Completion of this process presents a challenge, however, if the time between the request and a scheduled meeting is less than 4 school days. So let's talk about what is facilitation. SEMS facilitators enhance the efficiency and effectiveness of special education meetings using their management and communication skills. This optional service is funded by the Michigan Department of Education, Office of Special Education, at no cost to parents and schools. But remember, both parties must agree to participate. The goal of facilitation is to help families and schools navigate complex meetings, stay on task, and make sure all points of view are heard. Facilitators must always remain neutral. Expect the facilitator to open the meeting with a 3-minute opening statement, explaining his or her role and confirming the statement of understanding has been signed. They will also ask for questions about the process from everyone present. So the facilitator helps the team and process by modeling effective communication and listening techniques. They're going to work with the team to identify points on which they agree or disagree and make note of those. The facilitators maintain open communication and ensure that everyone at the meeting can participate fully. In addition, they can build and improve relationships among IEP team members, especially when they're having difficulty working well together. They're going to encourage parents and professionals to consider new options to address unresolved problems, helping people think outside of the box. They're going to help resolve disagreements more quickly than with other dispute resolution options available. And it's important to remember that the decision-making authority stays with team members who know the students best. So the facilitator does not make any decisions for the team. Their role is to really ensure that all participants are ready to move through discussion topics. And if disagreements happen, they're going to ask questions to arrive at solutions. They'll ensure printed documents reflect decisions the team made, and when emotions surface, they're going to pause for a break. Facilitators will also ask participants to listen to understand, not listen to respond. Science has proven that if you're listening to respond, you're not actually listening. Because facilitation is not an Individuals with Disabilities Education Act mandate, it's up to the school to decide if the facilitator will run the meeting or if a school designate will run the meeting. However, the facilitator works with the team to create an agenda and ground rules or communication guidelines for the meeting. And this is all based on the information that they have received from the family and the school. They're going to help guide the discussion by asking student-focused questions, such as, how's the student doing? What changes, if any, should be made to the student's goals? In what ways can we help them to reach their goals and objectives? They're going to keep team members on task and the meeting within the scheduled time frame. Facilitators will ensure the meeting pace is good for all participants. They will ask questions to clarify points of disagreement and help identify workable solutions. Help ensure that language in the special education or related documents reflects decisions made during the meeting, does not take sides, impose decisions on the team, place blame, or determine whether decisions are right or wrong. Expect the facilitator during the meeting to stop any sidebar conversations. They're going to help de-escalate when emotions may get high, to ensure that all parties have the opportunity to participate, and to ensure good use of time. The facilitator is a neutral third party. They are not part of the team. They do not give legal advice. They do not take sides. They will not place blame or determine whether decisions are right or wrong, and they do not impose decisions on the team. So the types of meetings facilitators can support are really any meeting dealing with a student's special education supports and services. These include, but are not limited to, an initial individualized education program meeting, a review of an individualized education program, an individual family service plan, a multidisciplinary evaluation team meeting, review of existing evaluation data meeting, a behavior intervention plan meeting, a manifestation determination review, a planning conference, and a resolution session, among others. Sometimes 2 meetings will be held back to back, and the facilitator should make sure that everybody understands each process and knows when one meeting is done and the other is beginning. Items the facilitator will be sure to address are who's going to provide copies of documents to the parent and guardian, who's going to distribute the documents to all of the staff that interact with the student, when will placement services be effective, or when will placement or services be effective, has the parent or guardian been made aware of their procedural safeguards, and do they understand the procedural safeguards, and any other action items from a meeting that need clarification. Could be additional meeting dates, who to contact with questions, and what happens next. Let's move on to mediation. The goal of mediation is for a neutral mediator to lead families and schools through a process to resolve conflict and come to a mutual agreement on a plan to benefit the student and improve outcomes. Here's the official legal description of mediation as a dispute resolution option. The Individuals with Disabilities Education Act describes mediation as a dispute resolution option that is voluntary on the part of the parties, not used to deny or delay a parent's right to a hearing or complaint, and is conducted by a qualified and impartial mediator trained in effective mediation techniques. Mediation can be requested anytime there is a disagreement about special education. This language was produced by the Michigan Department of Education Office of Special Education as of June 7, 2021. The benefits of mediation include helping everyone better understand differing points of view, working together on finding solutions, and retaining control over the outcome, rather than having a decision made by someone unfamiliar with the student. People are often more satisfied with and committed to mediated agreements because they're developed through a collaborative process. Disagreements may be resolved more quickly than with other dispute resolution options. Additionally, the mediator manages the conversation so that only one person is talking and may ask questions to clarify issues or to explain initials or acronyms used. Mediators will ask the parent and the staff to work on the reality of the decisions and how to best implement them. The mediator will refocus the participants, if necessary, to plan for the future of the student, rather than focusing on what has happened in the past. They will try to find the positive things that have happened and build on them. Items provided to the mediator are a list of priority issues, copies of pertinent documents, such as the IEP or IFSP and the like, evaluation data and reports, the names and emails of all of the participants, and the perception and background of identified or potential issues. To prepare for mediation, you should organize your documents and write dates and notes on them. Consider making 3 copies one for yourself, one for the other party, and one for the mediator. Make a list of the issues and questions you want to discuss during the mediation process. This can help you remember all of your concerns so you can present them in an organized manner. And think of questions other participants might ask and write down some possible responses. This is really going to help you prepare for a well thought out participation in a mediation. So try to think of many different solutions to the problem and write them down. What do you think other participants' solutions will be? What would you be willing to give up to help come to a resolution? How are you going to deal with emotions that may arise, yours and others, during the meeting? Also, it's important to try to arrive a little before the scheduled meeting time so that you have time to get ready to participate. The mediation is more likely to result in an agreement if everyone listens carefully to one another and is respectful. Participants should expect the mediator to remain neutral. They're going to conduct the mediation. In other words, they are running the meeting. They're going to clearly define the process that you're going to take part in. They're going to provide a 3-minute opening statement. They're going to remind parties of the confidentiality of the mediation. They're going to confirm the agenda and ratify it. They're going to ensure equal participation by all participants. They're going to make sure everybody abides by the rules of conduct. They're going to help parties stay on topic, guide parties toward the agreement, and then they will record the agreement. So mediators use a technique called supported negotiation. That is, they help to identify shared concerns. This might take some time because thinking of real reasons for a position can be uncomfortable. Mediation is confidential, and the mediator will help create an environment in which difficult conversations can be held. They're going to ask a lot of questions. And along the way, they're going to identify small agreements as the conversation happens. And they're going to intervene when someone isn't participating appropriately or effectively. This could result in a caucus, which is when the mediator will meet with each party separately to discuss the pressing topic. If it's on a Zoom platform, you will go into breakout rooms. If it's in person, you will physically relocate to somewhere private. They will ask permission before they share what may have been discussed in the caucus with the other parties. It's important to note that attorneys and advocates may and do participate in mediation to support the parties and the process. However, mediation is designed to allow educators and parents to speak for themselves and develop solutions to meet student needs. So let's talk about the mediation agreement. Participants will sign a form stating whether they came to an agreement or not. When an agreement has been reached, the mediator will support the recording of the terms in the words of the parties. They will help to flesh out terms of the agreement. Who is going to do what by when? What will the feedback loop look like? Agreements can be written for just the resolution of one item. This is okay. It's really okay to practice and build on the success of a resolution. It will help you build trust. It's going to help you acknowledge that you can do this. So if you had more than one item that you were in disagreement about, say there was 2 or 3 or 4, and you've come to resolution on one item, practice that, and then call us. Come back and work on the additional items. If you don't sign an agreement at the table, it's common for verbal agreements not to come to fruition. Unfortunately, this may lead to increased tensions, broken trusts, and an escalation of issues. Mediation can sometimes be an emotional and tiring, frustrating process. Parents and educators sometimes feel at a disadvantage if they don't take time to prepare before the session. Some complex situations may require more than one session to create a detailed agreement, and this is okay. And it's important to note there are no guarantees that mediation will lead to a written agreement. Again, as we stated on the previous slide, if you can come to an agreement on even one thing, that's really going to help provide the momentum to work together to resolve the additional issues at a later date. If dispute is resolved through the mediation process, the agreement must be in writing. It's going to be signed by the parent and an authorized representative of the school district. This is a person who has decision-making authority on behalf of the school district. And the mediation agreement must state that all of the discussions that took place during the mediation process remain confidential. The mediator is also going to review the next steps with the participants. They're going to ask who is going to be responsible for doing what. And they'll prepare an action items list. What will the resolution look like in the classroom, at the center, at the school? Who's going to tell the providers of special education supports and services about what was decided upon during the mediation and in the agreement? And then they're going to talk about what happens if the agreement isn't followed. So here are some common myths, untruths about mediation. One of them is that mediators will make a decision if the parties cannot. This is not true. Decisions in mediation are made by the parent and district representative. The mediator helps them share their ideas about the issues they don't agree on and tries to help them find common ground. The mediator will help the parties put their agreement into enforceable terms for the actual agreement document. Next, attorneys and advocates don't participate in mediation. We just talked about this. This is not true. Attorneys and advocates are welcome at mediation. They can provide important support and information to their clients. But remember, in mediation, the agreement is between the parent and district. The mediator will encourage the parent and district to lead the conversations, and parties can consult with their attorney or advocate at any time. Mediation agreements can't be enforced. This is also not true. Mediation agreements are legally binding documents in any court of competent jurisdiction. A party can be forced to participate in mediation. This is not true. Mediation is voluntary on the part of the parent and the district. SEMS intake is going to speak to each party to determine their willingness to participate in good faith. The mediation will not be scheduled, though, unless both parties agree to participate. What is discussed in mediation can be used in other legal proceedings. This is not true. What is said in a mediation session is privileged conversation and not admissible in any other legal or due process proceeding. And the agreement includes this language. The information may be discoverable, though, through other means. SEMS sends bills for mediation services. This is not true. Because of the funding that we receive through the Office of Special Education, mediation is provided at no cost to parents and districts. Only districts can request mediation. This is not true. Anyone can call Special Education Mediation Services to request mediation. The parent and district are the primary participants, though, and must agree to participate in mediation. And finally, mediators will provide legal or advocacy support. And again, remember, mediators are neutral. They do not provide any legal advice or advocate for one party over another. Finally, if your concern has elevated to a formal written state complaint or due process complaint, the last page of the Model Written State Complaint and Due Process Hearing Request forms gives the complainant an opportunity to have their contact information sent to Special Education Mediation Services. You are not agreeing to participate in mediation by checking yes. When this form is received, a SEMS intake specialist will conduct intake. It is important to note that SEMS does not receive a copy of the complaint or any information about the student before they call. The parent will be asked to provide this, and the complaint will be included as a requested record on the release of student information. Also, complaint timelines may come into play during this process. And finally, as a reminder, to contact Special Education Mediation Services Intake, please call 1-833-543-7178 or visit our website at mykidsfirst.org. Our office is located at 2111 University Park Drive, Suite 550, Okemos, Michigan, 48864. Our general office can be reached at 517-334-0034. Our fax number is 517-220-4181, and our email address is info@mykidsfirst.org. Thank you, and have a great day.